Well, welcome to this video in our series, Legal Bootcamp for Pastors. I'm your host, Attorney Joel Beck with Peach State Wills and Trust here in Lawrenceville, Georgia. And joining me today is June Lynn. She's a family law attorney with the Lynn Law Firm, also here in Lawrenceville, here in Gwinnett County. And she's going to join our conversation today about some basic divorce and family law matters that I think many pastors often see as they counsel folks in their congregation, in their community. June, welcome to our video series. Thanks for being here to join me today.
Thank you, Joel. It's an honor and a pleasure to be here. I really appreciate that.
Good. Let me start with an easy softball question for you, okay? Just tell us a little bit about who you are, what your firm does, what type of law you practice, your specialty, and the like.
Okay, great. Lynn Law Firm is a family law firm, and we focus on divorce, adoption, name changes, custody modifications, any kind of family legal action.
Okay.
And so our practice is probably 70% divorce and 30% the other cases that a family might need.
Okay. This series is really a legal boot camp for pastors or clergy folks who, in the context of their job, they're talking to people in their church or congregation or people just in the community, and they're seeing and hearing about a lot of different types of problems and situations. And I'm sure that a good bit of that deals with marital problems and maybe some issues or questions, concerns about divorce when things maybe get to a point where reconciliation isn't possible. So let me start with this. Give us a kind of a brief overview of the divorce process. What does that look like for somebody who's not really experienced with that?
Thank you. And most people only have one divorce in their life. You don't get married thinking that you're going to get a divorce. So that's a question that I get a lot. What is it going to look like? How long is it going to take? And some of that depends on the specific family circumstances. And it can also depend on the county where you're getting your divorce. For a divorce, you're going to file in the county where the married couple lives. And each county does things a little bit differently. I spend most of my time in Gwinnett County. And the process there, if your divorce is contested, it's going to take a year. It's going to take a year before you have finality. But that doesn't mean that you won't get some relief right away through a temporary hearing. And a temporary hearing is a procedure where the judge can make rules for the interim. Who's going to live in the house? Who's going to have the children on what nights? Is somebody going to pay the mortgage? Who's going to pay child support if there is child support? Those are temporary issues that a judge can take care of right away.
Okay.
If people have an uncontested divorce, and that would be parties that know exactly what they want and they just need to present it to the court and get a signature, that could happen in 8 weeks. That's a very fast process.
Okay. Wow. So it really depends on the situation for how things are going to play
Exactly.
out. But let's talk about the situation a little bit more. Are things different based on whether there are kids or no kids or the age of the kids or whether the couple can readily agree about how to divide things versus they're not in agreement? How do those types of differences impact a divorce case?
So it does matter. The more issues that there are in a divorce, the more complicated it could be. And then if you're scheduling a divorce trial, it could be a day, it could be 3 days. It's faster to get in front of the judge for 1 day. So anytime you can narrow the issues of your divorce, maybe say agree to property division, but let the judge make custody decisions, the faster you can have your hearing, the faster you'll get in. So it does matter. The one proceeding that I always want my clients to consider is mediation, because that can speed up the whole process and that can help people make an agreement and not need the judge to make the decision.
So let me follow up on that. For people who aren't familiar with mediation, what is that? What does that look like in this type of case?
Mediation is a process where a third party neutral will help the parties reach an agreement. So a party can either have a lawyer or represent themselves in mediation. But the nice thing about mediation is everybody comes to the table wanting to settle the case. So they're ready and they have all the information that they need to make the decisions. And the mediator is trained in helping people come to an agreement. So they may see solutions that nobody else thought of. They may help people reconsider the negative risk of going to trial. And their sole job is to push people towards the middle so that people make their own agreement. And the nice thing about that is a lot of times, especially when it comes to children, A judge might not give the parents the time that they need for the judge to make a really personalized decision. And so parents can come up with an agreement that is a lot more detailed and a lot more precise for their needs in mediation.
Okay. So you mentioned that people can represent themselves in mediation, or they can have a lawyer. And I know this is always a funny question to ask a lawyer, but when going through a divorce, when filing a divorce case, or going through that, should people have a lawyer?
Yes, everybody should have a lawyer, because I see so many times where there's only one lawyer involved and the other party doesn't know what's happening. And maybe they agree to some things that they don't understand. The words can, on paper, the words in a settlement agreement can look like they mean one thing, but if you're not represented, you don't have a legal explanation for what that actually means.
Okay.
So I always want everybody to have a lawyer,
Mhm.
both sides. Now, if there is adequate information so that everybody knows what are the issues and what are the facts, some people do it without a lawyer.
Okay.
But I always like everybody to have their own lawyer, because a lawyer cannot represent both parties in a divorce.
Sure.
And I've seen people where they think the lawyer represents both of them, but the lawyer can only represent one person.
Hmm.
So it's a disadvantage if you don't have a lawyer.
Okay. So if there's somebody that's going through a divorce, or starting that process, and they're considering their options and they want to talk to a lawyer, right, to gather some more information, what kind of tips or guidance would you have on how do you pick a lawyer for help with your case? What do these folks need to consider in regards to that question?
That is a very good question, because a lot of times people will ask around for a referral for a divorce attorney, and they'll hear more people say they hated their lawyer
Mm.
than they would recommend their lawyer.
Okay.
So I always want people to look at reviews, because the reviews are, for the most part, they're going to be unbiased. They're going to be people that have met with the lawyer or been represented by the lawyer, and they wanted to share their experience. So I always suggest to look at the reviews.
Okay.
Another thing that I think is really important is the lawyer that you're meeting with familiar with those judges. And the way to get familiar with the judges is to practice in that county frequently.
So location matters.
Location matters.
Okay.
So for me, I work primarily in Gwinnett, Barrow, Walton, Forsyth. And so if somebody calls from, say, Bartow County, I would not be a good choice for them, because I don't know those judges. And every judge does things a little bit different.
Mm-hmm.
So look for somebody who works in the county where your divorce is going to be. Next, I would say experience. Some attorneys do a little bit of everything. So they may know a little bit about everything, but the more experience somebody has in just the practice area that you need,
Mm-hmm.
the better.
Okay. Great tips. Great tips. Let's talk timing, though, right? You've already laid out that depending on the type of case that you have, contested versus uncontested, I think you said 8 weeks maybe in an uncontested case, but in a contested case, we might be a year or more in some situations in some counties. But what about before the case really starts, right? Are there any kind of timing requirements? Do people have to be in Georgia for a certain period of time? If they've just moved in, can they immediately get a divorce? Do people have to be separated for some period of time? Anything they need to know about the timing on the front end?
Excellent question. So the one requirement in Georgia is that you be a Georgia resident for 6 months.
Okay.
So that one can't be waived. A family that has only been here for 5 months is going to have to wait 1 more month to file in Georgia. Now, you might be able to file in whatever state you came from, but you cannot file in Georgia until you've resided here for 6 months. You do not have to be separated for any length of time. In some other states, you have to be separated for a year before you can file for divorce. In Georgia, you don't have to be separated for any length of time. You do have to be a resident for at least 6 months.
Okay. So let me follow up on that. You threw out the S word, separation or separated. What if one spouse really isn't quite sure yet if they want a divorce, right? But they think a separation might be a step to take. Is there such thing as a legal separation in Georgia? Or maybe somebody had heard something called a separate maintenance agreement. Is that a thing in Georgia? Tell us about this type of concept.
There is a legal separation in Georgia, and it doesn't just mean we live in separate places. You can file a suit for separate maintenance, which is what a lot of people think is the separation.
Okay.
And what's really important about that is it's not a divorce, but when you file, the courts enter a mutual restraining order, which prohibits parties from taking financial actions which could basically cause harm to the other party. For example, if you just move away from your spouse or your spouse moves out of the house, nothing prevents them from shutting off the utilities, changing your insurance, stopping paying the mortgage. But if you're going to do that and you file a suit for separate maintenance, a mutual restraining order will prevent them from doing that. I think in many cases, if people want a trial separation, it's often a good idea to go ahead and file the suit for separate maintenance. Okay. And in that, the judge can give you a separate maintenance decree, can divide your belongings, and can order alimony or whatever, but you would still be married to the other person. You could always file for divorce down the line if you decide that is what you need.
Okay, great information. Let me ask you this, June, as our time for this video is coming to a close here. What other information would you want to share with somebody who might be in our audience, a pastor, clergy person, speaking with a couple, and they've got somebody that's considering a divorce or kind of starting that process? What's important for our listeners, folks in our audience to know? Anything that we haven't covered so far?
Okay, so one thing that I would caution counselors and clergy against is encouraging people to come to an agreement before they have the information they need to do that. Sometimes in the situation of counseling parties to a divorce or parties who are thinking of a divorce, the clergy or therapist may help them start making decisions about how they're going to divide things or who's going to live where or what they'll do with the children. And it's important to get legal advice before you make any concessions, because there are natural consequences that flow from certain decisions that people may not be aware of. For example, child care. If somebody makes an agreement about sharing the children, parenting time, they may not understand that there's going to be financial ramifications that come with that agreement. Or if they're deciding who's going to stay in the house, the person staying in the house might not understand all of the costs for that or what else that means for the rest of their settlement package. So it's important to maybe make an agreement to be fair to the person or make an agreement to make no changes until a lawyer has advised the client. But I would not want people to sign documents, even in a counseling session, until they've found out what their rights are.
So it sounds like they need to make sure that they've got a full and fair disclosure of all of the facts before then determining actions to take going forward.
Exactly.
Okay.
Exactly.
All right. That's great information. Thanks for sharing that and all of the things that you've shared today. If somebody wants to get in touch with you to learn more about your practice, or maybe you might be able to help them or somebody that they're dealing with, how can they find you?
Thank you for asking. It's www.lynnlawga.com. That's LYNLAWGA.com. And our phone number is 770-212-9090.
Great. June, thanks so much for being here. Thanks for joining us. To our pastors and our audience, continue to watch for the other videos in this series. June's going to join us for another video, diving into another separate issue with respect to some family law stuff. And then we're going to have some great attorneys in other practice areas that are going to be able to share a lot of valuable information. Until then, that's it. Thanks so much.